Now what I thought we would do is we've heard about all these problems in the world and we want to do something about it. So we want to use the courts as to be lawyers. So we're going to see what can we do about litigation. So what I thought we'd go through is here's a few tips about having successful public interest litigation. Now what I'm going to do is I'm going to group it in 4 categories. First, we're going to pick our cause of action. So what are we going to take to court? Second, we're going to do a bit of the precautionary principle. We will anticipate what the forces of darkness are going to do. Having got that, we'll be ready to start. We're then going to do our case preparation and we'll work it up to the case walking into hearing, and then we'll run the hearing. The missing part is the judgment, you don't get that. Okay, so let's start off. So here, I'm going to go through each of these, but these are just the sort of the synopsis of my topics to cover. You guys have got to be the activist. Okay, it's not going to be the court. You've got to be creative. Okay, so we're going to break sort of traditional ways of thinking. You've got to show the way. Okay, you've got to be the leader, not the court. You've got to choose a suitable vehicle. Too often people pick the wrong case, facts to bring. Remember, contrary to most people's belief, judges are human, and you've got to have an emotive hook. Okay, you don't want to make it sort of dull and boring. You've got to sort of hook them right in the beginning and grab their attention. You've got to show there's a remedy. Okay, so good going to court, winning, and then finding you haven't got a remedy. And the last one is, don't sort of go in with a scattergun. That's what blunderbuss, you send sort of all sorts of shots. You don't know which one's a good one, but you certainly hope that one of them hits the target. Not a good strategy. Okay, so let's go through some of those. The first one is about being the activist. Now, courts are responsive organisations. We know as a general rule, it's the sort of adversarial litigation culture in Australia. It's not an inquisitorial system. That's breaking down, really. The courts will be far more inquisitive once the case comes. But they can't go out. We don't do what, say, the Indian Supreme Court does. You've heard about the Suamoto jurisdiction. They're sitting reading the paper and they see that there's a toxic dump somewhere and they say, that's not very good. I'm going to call these parties in and we're going to start some litigation. It's not very popular in Australia. So you guys have got to be the ones who have got to come up with the ideas and take it to the courts. And remember, if you don't give a good idea, you don't come with a good case, how are you ever going to develop environmental jurisprudence? How are you going to get environmental justice? Okay, so you guys have got to be the active ones. And you've got to give the opportunity to develop environmental jurisprudence. There's no good lamenting that the courts are just sort of, morbid and depressed and conservative organisations. If you never give them the opportunity, how can they develop the law? So the next one is be creative. Now, don't get stuck in a rut. It's very easy to do that, and environmentalists do the same. It was a point that you made, saying, the main thing environmental laws are to regulate environmentalists. We're getting stuck in the rut. If every time we see an environmental problem, we come up with the same old cases about what we might do, then we're in the rut. Okay, so think creatively about it. Now, if we think about it, who can remember Hans Kelsen? Grundnorms. Why shouldn't we make, environmental law or sustainable development the Grundnorm, under which all other law must conform? Right? Let's stop thinking about environmental law being a little pigeonhole, that little elective that the loopy people go and do, but the really important people go and do tax law and other things. Okay? We're pigeonholing ourselves then. We're getting stuck in a rut. Let's start thinking that environmental law should be the overarching law and all the other subjects should be subsets. Give you an example. Let's think about climate change. The first thing we think about is rush off to VCAT, okay? Do a sort of a merits review, nothing wrong with that. Or judicial review, the cases such as the Grey litigation in New South Wales about the Anvil Hill Colliery. But why do we stop there? Environmental law is far more than that. Let's think about it. Constitutional law. We started getting some of the ones up there about constitutional rights. Now sometimes they're express. They actually say something. If you've got Ecuador, you've got one about rights of nature. If you've got the Philippines, you can think about the healthful ecology. But it doesn't have to be. It could be a right to life. Right? A right to life it can include something more than bare animal existence, one hopes. It's not like that Monty Python one where sort of, they drag them out and he goes, I'm not dead yet. Yes, you are. No, you're not. Okay, it's a certain quality of life. That's what environmental justice is talking about. That is, you have a certain quality of life, right to clean air, clean water, be able to, not have this toxic dump right next to you and, lead poisoning, whatever it be. So we can think about constitutional law. We can think more generally about human rights. What about before it disappears in Victoria? Can you use some of the human rights provisions and with an environmental context? What about in the common law? What about human rights there? Go back to Magna Carta. You've got as many High Court decisions which say that fundamental sort of human rights are there. And that, for example, one of the things of statutory interpretation, principle of statutory interpretation, is that one should not interpret legislation to take away life and liberty. Well, there's life, isn't it? We've got it there. Let's think about it. So is it implicit in the fabric of our law that there is a right to life? Do we need a constitutional provision? Can we uphold some sort of human right? And if so, we can then bring in a right to certain quality of life. Tort. We all did that, not second year probably, about the torts, and we also did that. But what were those cases? They were fundamentally environmental cases. Right? They were a few hundred years ago, but nevertheless, there they were. And what's happened now? No one really seems to use, the tort cases. Now we see in climate change, particularly in America, they're using public nuisance, private nuisance, negligence. And so there's a resurrection. We could be thinking about using some of those. But what about some other ones? Let's think about the tort of deceit. Right? If there is all these sort of greenwashing going on, right? There could be a tort of deceit there, or negligent misrepresentation. Go into contract. Again, you go and buy a contract. Why not? Be an environmentalist. Go and buy some dodgy product and then sue in contract. Okay? Go and hire. Click on the box when I fly down here, Virgin. That's why I was an hour late. Where they say, tick on the box and for $13.52 you've just offset or something your thing. Is it really, your flight of carbon? I don't know, but somebody, why not check it out? Find out whether that's just dodgy. What do they do with the money anyway? Where does it go? Okay, there's a contractual case, you can have a look at. And also, just think about this, that old thing, years ago I wrote on this, but about something can be void for public policy reasons. Now, there's a whole range of things. Slaves are not very sort of politically correct today. But you could set aside, if you bought a slave in a contract, you could set that aside as being void for public policy reasons. But there could be a whole lot of environmental ones we could be thinking about. Or property. I've got public property there, but private property could also work. Some of the litigation has been done by these organisations like Nature Conservancy or private organisations that own environmental nature reserves, and they are being adversely affected by climate change, or they would have some property right which is being infringed upon. We can think about public property. What about urging the government, with or without the Attorney General's fiat, taking action to try and protect national parks, reserves, parks against impacts. The public trust doctrine, big in America, been very successful there. Why isn't it working here? Where are the cases? Trying to use that ancient Roman concept of the public trust. It's waiting for a case, people. Bring one. Corporations I didn't put up there, but what about corporations? Go in and start buying shares in all the Dick Dastardly companies. And then goes on to, there's certain powers that you have to requisition, ask for certain things, demand environmental audits, demand that their annual reports disclose what is their water consumption, their use of energy, their greenhouse gas emissions, etc. Okay, so there's a lot of things that you can do there. So there I was just trying to give you ideas. Think much more creatively about the causes of action. And remember, although we float off down close to Antarctica, we're not alone. Increasingly, environmental law is becoming globalised and it's being harmonised. So go and look at international law, look at the treaties from which so many of our laws stem. Get ideas from that, see what's been happening. Look at the laws of other countries. There may be some things there that you can see that you can use. And of course follow litigation in other fora, so international ones. Go and look at what's happening in the European Court of Human Rights, for example, get some ideas there. Go and look at any sort of litigation, not much happens ICJ, but WTO or appellate body or something else. Have a look and see what might be an idea. Or look at the national courts. Try reading regularly what is the litigation that's happening all around the world and keep thinking, how could I use that? When we founded the EDO, the first of them, in New South Wales, I had a rickety old desk that we had found abandoned in the slumming end of Pitt Street, and so that was our first desk. And I had a sort of a drawer which didn't really quite close, which was quite useful. And so every time I actually saw a case around the world, I would scribble on a bit of paper and write that case down and say, don't know how I'm going to use that yet, but it's a good idea. And then every now and again, somebody would walk in, a client would walk in, and they'd sort of say, here's my problem. They never come in and say, here's the cause of action. They just say, here's my problem. You've got to find something for them. And then I'd go, I think I've just got the case for you. And down I'd go with a little drawer which didn't close, pull it out and say, this is your case. And we would then run that sort of case. So that's what you've got to do. Keep an idea source from other places. All right, next one.